Speaker.
This will be a split call. Chris Farfoy, 5 minutes.
Thank you very much, Mr. Speaker. Mr. Speaker, before I hand out a few brickbats, let me hand out a few bouquets. And first of all, to the Justice and Electoral Select Committee. I understand Scott Simpson is the chair, Jackie Blue, my colleagues Andrew Little and the Honourable Leanne Dalzell, and also to those who submitted to the Justice and Electoral Committee on this bill, because as Phil Goff said, we've got a bill in front of us at the moment at the second reading, which has been amended, a good bill, and it is a perfect example of how the process works when good legislation goes through this House. It has cross-party support, as the Honourable Kate Wilkinson said. There has been a lot of consultation with opposition parties to make sure that this very important piece of legislation will go through the House and have wide support of this Parliament, because it is a very, very important piece of legislation in terms of our criminal procedures. But you contrast that, as the Honourable Phil Goff said, with the pieces of legislation that we had before this around the GCSB and the interception of telecommunications, where the process has been an absolute farce and an absolute shambles. And it is also a very important piece, those two pieces of legislation, very important in terms of oversight of our intelligence committees. And you really do have to look at the way that the government has put this piece of legislation through in what I think is a very good manner, and we've got a very good piece of legislation before us, and what happened before this piece of legislation in terms of those two bills. And we've also got the situation where last night we were debating the truncation of the select committee stage of one of those pieces of legislation, again taking away the ability for the scrutiny that is absolutely needed when we're talking about the surveillance of New Zealanders' telecommunications. Again, in complete contrast to the process on the select committee with this criminal procedures legislation bill. I understand there are only two submitters to this bill, the major one being the New Zealand Law Society, but you have to contrast the ability of people who are aware of the situation in this criminal procedures legislation, with the Law Society coming in and making a fulsome submission to the Select Committee. That Select Committee went away and listened to those Select Committee, listened to that submission, made the appropriate changes in the appropriate length of time. But in the previous legislation that I was talking about here, we have a truncated Select Committee period about a piece of legislation which goes to the heart of democracy and also the oversight of our security intelligence agencies. And as the Honourable Phil Goff has said, you can hardly make sense of the contrast of the process with the criminal procedures legislation bill and the legislation that this government put in through this House yesterday in terms of the changes that it is making to our intelligence agencies. As has been said before, Mr. Speaker, this is a bill which makes technical amendments to, I think it is the Criminal Procedures Act, which was put through this House in 2011. It has come out of work that was started by the Labor government in 2007. And I do want to just reiterate the words that the Honourable Kate Wilkinson said, that while it may be just slightly they may be technical amendments, they are very important amendments to make sure that the Criminal Procedures Act actually works for those people who are going through our court systems, because there are some serious issues around delays in our court system, also the increasing costs of getting justice in our court system, and also the complexity of the court system for those who are going through it, and that is for victims as well as defendants. So it is absolutely fundamentally correct that we should put through this legislation to ensure that the quality of justice that those victims and those defendants are getting in our justice system is as good as it can be. Mr. Speaker, there were, as I did say, there was one major submission to the Select Committee by the New Zealand Law Society, and that was basically around some concerns around the Henry VIII clause, which has been well traversed, around the definition of crime and the ability to change the definition of crime by regulation. And I just wanted to congratulate the Justice and Electoral Select Committee for taking that on board and making sure that that part of this bill was removed. Because, as I say, say. This is a case where, where a select committee has listened and has acted, and the process was good. But I reiterate that in other bills that are before this House on this day of urgency, that has not been the case.
Jan.